is approaching the podium as we speak. Mr. Duffany, please introduce yourself to the court. Thank you, Judge. Today's the date and time set for probable cause conference. I was just appointed on this matter yesterday afternoon, so we are asking for a brief adjournment for discovery and for plea negotiations. At this time, there's also a bond violation, or
there is.
Yes, Judge. So I spoke to Mr. Duffany. He went to community corrections yesterday at 4:20.
But he couldn't take the test because he didn't have the money. Welcome to the justice system where your wallet can be your worst enemy. But here's the kicker. The judge still wants him tested today.
He PM'd, but he did not have the money to test, so he was unable to. We did discuss today, he's going to go immediately to community corrections after this. I do have an email from community corrections to confirm that he was there.
Is he going to test clean?
I believe so, Judge, yes. He's on what?
Are you going to test clean?
I'm on Suboxone. I'm prescribed Suboxone.
You're prescribed it? I'll pass it. He needs to get over there and test and then come back.
So thank you, Judge.
I'm not doing that anymore. Takes a lot. Just go on. Okay. Court recalls the case People versus Justin Duffany. Yeah.
Good afternoon again, Your Honor. Good morning, Chief Assistant Prosecutor appearing on behalf of the people.
Can I put it back on the record with Mr. Duffany? Justin, please state your name for the record.
Justin Duffany.
Boom. There it is. Cocaine on the results. And just like that, the bond is revoked. This is where everything flips. The courtroom just went from negotiation mode to damage control.
I've seen the results, Judge, and I have gone over them with Mr. Duffany.
He doesn't have a prescription for cocaine, Mr. Allen.
I would assume no. Gonna be all right. Gonna be all right.
All right. I'm going to adjourn the probable cause conference to August 14th, 2025, 9 a.m. His bond at this time, given the violation, is bonded.
Thank you, Judge.
Good morning, Your Honor. Assistant Public Defender Constable Bass on behalf of Mr. Brandon Bowman, who's present to my right. Can you state your full name for the record, please?
Brandon Charles Bowman.
Now, today's date and time set for a probable cause conference. At this time, respectfully requesting you set this for an exam.
If I could address bond, Your Honor.
Are you going to address the additional bond violation report that we have? There's something else?
Yes.
Oh, lovely. All right. You want it set for exam,
Yes, Your Honor.
and you have the discovery.
To my knowledge, yes.
Would people have their witnesses available at 12?
Do my best, Your Honor.
Preliminary examination in person will be set August 12th, 2025, 9 a.m. before Judge Fresh Hour. As to bond.
Your Honor, I believe the defendant is in custody on a no contact order bond violation originally.
Intro, he tried to call the victim 21 times from jail after being told not to. That's not persistence. That's a direct ticket to a bond denial. Judges do not play when it comes to no contact orders.
After he was put back into custody, he's tried to contact the victim 21 times. None of the calls have been successful, but he has tried to call her listed number in the police report since being put back in for violating the law.
And at this time, what's his bond? Is it revoked?
I have it as denied, Your Honor.
Yeah, that's what it should be. All right. As to that, Mr.
Your Honor, I haven't seen anything about these calls. My client is saying that
I have not made one phone call.
Your Honor, he's going to be asking for a PR bond. He's been in for 8 days.
Is the phone calls that he made, is that attached to his pen?
Your Honor, I'm trying to pull up my it's not.
Okay. I understand you're saying that none of the calls were completed, but were they made from his pen? That's what I'm trying to figure out. Well, why don't we do it this way? Mr. Bowman, you can talk to the prosecutor's office regarding that. If they did come from, I'm going to, at this time, I'll revoke his phone privileges. I will reinstate them if they did not come from his pen. Okay. So get with the prosecutor's office and I should have that answer as soon as their internet goes back up. All right, sir? All right. Otherwise, bond will continue as denied.
Your Honor, we have it pulled up real quick.
Oh, you do have it? Hold on.
They're from different pins.
They're from, are any of them his?
No, they're all different pins. There are 2 different pins that are being used, but not this.
And none of the calls were connected?
Correct.
All right. I'm going to deny the request then to have his phone privileges revoked at this time.
Your Honor, my client is asking for a PR bond. He's been in for 8 days.
I have a conditional bond violation. That's why he's in.
I understand. He's willing to admit to the bond violation and ask for the 8 days without a hearing. If
That I would not be sentencing him to the 8 days on it.
Understood.
I can tell you that. So does he still wish to admit to the violation? Yeah. Well, that's okay. Yes, I need one for him.
Okay. Understood, Your Honor. Then we'll keep it as it is.
Sorry. Once I check your screen.
She got mad at me. I'm just a figurehead.
Alexander, on behalf of the people, Your Honor.
Robert, on behalf of Mr. Amerson, is approaching the podium. Amerson, please state your name for the record.
Mario.
So, Your Honor, there's a date and time set for probable cause conference. I was recently appointed. However, we are asking, I do not believe that there is video in this case, so we are asking that the matter be set for preliminary exam.
Up 100 calls to the victim. From jail? If you ever wondered how to lose phone privileges in record time, this is it. Even the judge sounds like she's had enough.
And if I could address Ron for free, Your Honor.
Why am I not shocked? Okay. So you believe you have all the discovery?
I believe so, Judge.
Would the people have their witnesses available to 12?
We'll do our best, Your Honor.
Preliminary examination, August 12th, 2025, 9 a.m. That is before Judge Freshour. Yes, that's the bond.
Your Honor, it's come to my attention that Mr. Amerson has called the victim in this case 100 times since his arraignment. So at this point, I would be asking.
What? 100 times?
100 times.
Okay.
So I would be asking that his phone privileges be revoked. It's her listed number in this report as well.
Response?
So, Your Honor, I spoke with Mr. Amerson in the jail recently. We went over the no contact.
That wasn't on the phone, was it?
No, Judge.
My bad. Go ahead.
Technically, it was, Judge, because it was through the glass. So we did have a discussion on it. I explained that the no contact order, even if he receives contact from the complaining witness, he's not allowed to respond. Or to, I don't know, I got it. Or if he is, even if she wants contact, it's my understanding that she does want the no contact order lifted, but we did explain what it means to have a no contact order in place. And going forward, I'm confident he will not be making any more contact and reaching out to the victim at all.
Excuse me, just talk, man.
What do you want to say?
She came to visit me, man. They let her come visit me, so it couldn't have been that serious of a non-contact.
So, we did discuss what the no contact order means. And so at this point, we are asking we're already set for preliminary exam. So, and in the,
Domestic violence or nothing, man. It's fraud, man.
we got it. It's my understanding that the complaining witness has reached out to him several times, so that he didn't really understand what the no contact order meant. We've explained it. We've hammered down that no contact means no contact. So that at this point we are.
Let me ask this then. Other than those times where the defendant's alleging that the victim has come with him, are the phone calls his calls out to her?
Now he's arguing that if the no contact order was serious, she wouldn't have been allowed to visit him. That's not how legal boundaries work. The courtroom isn't going to buy. But she came to me, Your Honor.
Some are from his pin and some are from other pins.
Well, I understand that, Mr. Burdell, there might be a mix-up when she comes there. And
I got one more thing to say, man. You ain't wearing it right, man. Excuse me, can I talk? I know how to talk. You feel me? I got you. She came.
Sure, go ahead.
She came to the jail to visit me.
I heard you.
I haven't seen nothing, and mail said no contact. How's she able to visit me if it's a no contact order and I'm in jail?
That I don't know, and that's why I asked if there were. I'm trying not to take those contacts where she's making them with you into consideration, because your attorney just explained that you had a conversation about how you have to respond to that. Then I asked, were there phone calls from or contact from you to her, which would be strictly prohibited?
Right. I was under the impression that I wasn't able to have no contact upon my release. They said during bond.
And there. It is the gavel drops on his phone privileges. It's his courtroom accountability 101. When the judge says no contact, she means it. You'll have to earn those calls back in front of Judge Freshour.
We can't be in the same household. They never said about calling her from jail. This is not no domestic violence issue. This is a fraud for $30. That she clearly called the prosecutor and said she didn't want to press charges.
I don't know any of that, sir.
Like,
I don't.
Because they telling you half the story, man.
I'm not going to get that information right now. I'm not supposed to have that information right now. Anything else, Mr. Anything else, Mr. Burdell?
No, Judge, not at this time. Thank you.
At this time, and this is only for the calls that he's making out, either from his own pen or from other pens, because that is not allowed and strictly prohibited. Defendant's phone privileges at this time are revoked. You can make the argument before Judge Freshour to reinstate them after the preliminary examination.
Thank you.
Thank you.
Maybe 5, man.
What'd you say?
5.
Come talk to him, Mario.
You just want me to go? You don't want me to go? You want me to stop on that and say something? You just want me to keep going? Really? Okay. All right. I'm gonna pick up the next one. And just... This is on your advice, because I got something to say, but I'm not going to. Court calls again.